All right, good afternoon, everyone. My name is Danae Aber. I'm the Executive Director of the Louisiana Rural Health Association. Thank you so much for being here today for this webinar, Navigating HIPAA, Breaches of Protected Health Information and Privacy Laws in Louisiana. LRHA is happy to host this webinar presented by Robert Wilson with Nelson Mullins, Riley & Scarborough, and the Rural Healthcare Initiative. This webinar will provide a comprehensive overview of the Health Insurance Portability and Accountability Act, breaches of protected health information, and privacy laws specific to Louisiana. This webinar is being recorded and will be available along with a copy of the slides on our webinar recordings page of our website. I will drop a direct link to that website in the chat momentarily. Your line should have been muted automatically when you join the session. Oh, I see someone's hands raised. Someone's hand is raised. I'm going to pause momentarily if someone can't hear me. Okay, it looks I don't see anything in the chat. Apologies. Your lines are muted automatically when you join. Please remain on mute to prevent background noise. You can enter any questions that you might have in the Q&A box or any comments in the chat box. We are going to try to take questions at the end of the session if there's time. If we run out of time, please go ahead, still put your questions in the Q&A and we'll respond to those via email after the session if we need to. After the webinar, a survey should automatically open in your internet browser. We do ask that you complete that survey as it helps to continue to improve our future events and provides ideas for future education topics. And so with that, I would like to welcome Robert Wilson. Bob, as he usually goes by, is a partner with Nelson Mullins, Riley & Scarborough, and a co-founder of the Rural Healthcare Initiative. He has worked for more than 40 years with healthcare industry clients to find innovative and compliance business solutions in the constantly changing healthcare industry. Bob devotes his law practice to the representation of healthcare providers such as community hospitals, healthcare systems, academic medical centers, physicians, and physician groups, among others. As the co-founder of the Rural Healthcare Initiative, he focuses on the preservation of local access to healthcare in rural communities in the U.S. The initiative was named winner of the 2022 FT Innovative Lawyers North America Award in the responsible business category, and Bob received a commendation for his efforts. So thank you so much, Bob, for being here today, and I'm going to hand it off to you.
Okay, thank you, Danae. Can you hear me okay?
Yes.
Good. It's really nice to be with you all today. I am in Raleigh, North Carolina, where I live. I have enjoyed visiting Louisiana on a number of occasions and look forward to the opportunity to return. Today, we've got a pretty full agenda, lots of information. So as Danae indicated, I thought maybe it might be best to defer questions till the end because I'm not sure I can get through the material that I prepared in an hour, or actually less than an hour now, but I'll do my best. What we're going to do is talk through see if my slides are not advancing, Danae, for some reason.
I think we need you to share them again.
Oh, okay, hold on. Sorry about that. Does that work?
Yep, we can see them now. Thank you.
Okay, sorry about that. What I wanted to do is talk about just some HIPAA basics and Louisiana law, talk about breach notification. I think an important topic that Danae and I discussed was how do you maintain compliance with limited resources? And then I thought I would go through some liability and enforcement examples. So let's start with HIPAA basics and Louisiana law. What is HIPAA? I know that probably everyone online knows what HIPAA is, but I just wanted to be sure that we level set. HIPAA, of course, is a federal law that was enacted in '96 to create national standards that protect sensitive patient health information from being disclosed without the patient's consent or knowledge. HIPAA governs access, use, and disclosure of protected health information by covered entities. Those are, of course, healthcare providers, health plans, healthcare clearinghouses, as well as business associates. And we'll talk about that in just a minute. A business associate, of course, is a person or entity that performs certain functions that involve the use or disclosure of protected health information on behalf of a covered entity. So what is protected health information? HIPAA defines PHI as that which is that health information which is transmitted or maintained in any form or medium. This includes databases, emails, electronic medical records, patient portals, things like that. Individually identifiable health information is a subset of health information that includes demographic information created or received by a covered entity or an employer that relates to the person's health care and can be used to identify that person. Of course, this includes past, present, and future health conditions, the provision of health care to the individual involved, and the payment for the provision of health care. There are some records that are that do contain individually identifiable health information that is not covered by HIPAA. These are records that are produced by other parties and discovery records that are obtained from public sources, employment records, workers' comp records, and education records. So what is a business associate? HIPAA applies to covered entities and business associates, as I mentioned just a moment ago. Business associates are the third parties that create, receive, maintain, or transmit PHI on behalf of a covered entity in the course of providing administrative services to the covered entity. So before a covered entity can begin providing PHI to a business associate, it has to enter into a business associate agreement to assure contractually that the BA complies with the HIPAA requirements of the security rule and the privacy rule, as well as require the BA to report to the covered entity any occurrences of a breach of PHI. A business associate is an entity like me. My law firm is a business associate of my clients. We will occasionally receive health information from our clients. There are companies that store record companies that store PHI, and other vendors that have access to PHI. Often consultants fall in that category and contractors of a number of types. Business associate agreements have to be extended to all subcontractors of the business associate that have a need to create, receive, maintain, or transmit the protected health information for or on behalf of the business associate. So again, talking about the business associate agreement, it's the contract that's covered between the covered entity and the business associate, and is required anytime the business associate will create, receive, maintain, or transmit protected information on behalf of the covered entity. And of course, the BAA has to require the business associate to comply with HIPAA rules, report breaches, and impose the same requirements that it has as a business associate to any one of its subcontractors. BAAs also outline a large number of other really important provisions, such as potentially indemnification of the covered entity in the event of a breach, and a timeline for breach notification. But even if the agreement is not formally in place, you should know that HIPAA regs still extend to the business associate and create liability to the business associate who is in that relationship. So let's go over some key BAA issues. So as I've talked about, the key purpose of the agreement is to establish how the business associate is permitted to use and disclose PHI. The business associate is not permitted to disclose PHI in any way other than how it is permitted to do so by the BAA itself or by law. The agreement is generally going to include provisions on things such as data aggregation, which is basically the combination of PHI by the business associate with PHI it receives from another covered entity for the purpose of data analysis. Also, de-identification of PHI is covered. I'll talk about that in an upcoming slide, as well as the creation of limited data sets containing PHI, which I'll go over in a minute as well. The agreement is also going to cover the management and administration of the BA's operations relating to how the BA is going to use and disclose PHI under the scope of the engagement with the covered entity. Other key BAA issues include the need for the BA to subject their subcontractors to the same requirements or stricter requirements that the business associate may be under. The subcontractor can include services such as consultants or tech providers who handle or access data containing PHI. But in any event, the business associate agreement has to be equally or more stringent than the originating BAA with respect to the permissible uses and disclosures of PHI. Some areas to focus on with business associate agreements, apart from the language surrounding permitted uses and disclosures, include things like specific privacy and security requirements, such as those implementing reasonable administrative and technical safeguards to protect access to PHI. As I mentioned, indemnification of the covered entity in the event of a breach, including the payment for breach costs. This could include things like requirements for cyber insurance, and also things like the timing of required breach notification, which is generally within 24 hours or a reasonable time of the discovery of the breach. With regard to business associate liability, business associates are directly liable. They're responsible for violations of the security rule. And this is really the area where we see a majority of noncompliance with HIPAA requirements by business associates. Appropriate security measures encompass all of the administrative, the physical, the technical safeguards on an information system, and include activities such as conducting a security rule risk analysis to ensure compliance with HIPAA, establishing a risk management program that will audit and review internal and external risks to PHI, as well as establishing written procedures and policies outlining how the business associate is complying with HIPAA, and will ensure those policies should ensure the proper use and protection of PHI. BAs are required to train employees and workforce on cybersecurity issues and best practices, and designate a security official within the BA in order to handle and manage day-to-day security operations. There is no obligation to under HIPAA for a BA to designate a privacy official within the BA's organization, but some still do it as a best practice. What is de-identified information? Under HIPAA, this is health information that does not identify an individual, and there's no reasonable basis to believe that the information is somehow able to be used to identify that individual. Since there's no link between de-identified information to the individual, there's no direct privacy and security concern, which therefore exempts the information that's de-identified from HIPAA coverage. There are two methods for de-identifying PHI. One is an expert determination that the risk is small, that the information could be used to identify the individual. And there's a safe harbor exception that requires the removal of all 18 identifiers from the record in order for the information to be deemed de-identified. I mentioned the limited data set as well earlier. Just a quick word on that. A limited data set is PHI that excludes the 16 identifiers of the individual, the basics such as name, social security number, email, telephone number, that kind of thing, that can be used only for the purposes of research, public health, or healthcare operations. It is sometimes referred to as a light version of de-identification, since some information is permitted to remain, such as dates and certain geographic information. The preparation of a limited data set information by or for a business associate requires the business associate to enter into a data use agreement with the covered entity. This is a sort of, again, light version of a BAA, as it requires less restriction and obligation on the BA due to the lessened risk that occurs because the potential harm from a breach or misuse of limited data is less. So what are some of the uses and disclosures of PHI? Covered entities and business associates can use or disclose PHI as permitted by HIPAA. In general, though, either party can disclose PHI, of course, to the patient, who's the owner of the PHI, for the purposes of treatment, payment, and healthcare business operations, pursuant to a written authorization of the patient as to how they're permitting their PHI to be used or disclosed further. It can be disclosed to law enforcement in certain circumstances, such as that circumstance that might involve the risk of health or safety to an individual, or maybe as required by law or as ordered by a court. As you may remember, there is also something called a minimum necessary standard. This requires under HIPAA that the covered entity or BA use or disclose only the minimum information that's necessary to accomplish the intended purpose or use or disclosure. So the use or disclosure of any additional information beyond what is minimally necessary is a violation of this rule. The minimum necessary standard does not apply to disclosures or requests made by a healthcare provider for treatment purposes, or in some other circumstances like being required by law, or in accordance with an authorization from a patient. There are some HIPAA preemption rules, and we'll talk about those, and some Louisiana law requirements as well. Just briefly, HIPAA, of course, serves as the baseline of protection afforded to PHI. And if there's a conflict between HIPAA and the state law, whichever law that provides the most protection for privacy of the patient's protected health information or permits a greater rights to the individual, that's the one that applies. You're probably more familiar with some of these requirements, but they're very standard nationwide in many instances. I did note in my research that the legislature is in the process of considering a Consumer Privacy Act, SB 199. But last I checked, the bill is still in committee. But there are some existing regs that afford additional levels of protection in certain situations, such as the requirement I saw for HMOs to keep patients' health data confidential, and of course a requirement to keep HIV test results confidential. The law also provides, under the Hospital Records and Retention Act, the statutory right of access of patients to their medical records. There is also, as is in every state, a healthcare provider patient privilege that can be waived under certain circumstances under the Louisiana Code of Evidence, such as cases that might involve child abuse or molestation. I'm sure there are others as well. Because of the nature of our work in rural America, I wanted to include, and I know in my discussion with Danae, she thought it would be helpful to have this slide included relating to the concluding HIPAA waivers on telehealth. I know that many of you employ telehealth, telemedicine technology, and so it might be important to remember that during the public health emergency, DHHS had a number of HIPAA waivers that they said would not take it, pursuant to those waivers, they would not take any enforcement action or actions for non-compliance with HIPAA requirements in a number of circumstances, including the use of telehealth by covered entities. But now that the public health emergency is ended on May 11th, the HIPAA waivers are also coming to an end. The Office for Civil Rights has given covered entities and business associates a 90-day grace period ending on August 9th to allow ample time to bring telehealth practices into compliance with HIPAA rules. So providers using telehealth technologies should use the transition period we're in right now to review their telehealth operations, including specifically their arrangements with any telehealth technology vendors, identify HIPAA compliant telehealth vendors, and make sure that your BAAs are current with those vendors, and take steps to ensure that the provision of these vendors of telehealth services complies in all aspects, of course, with HIPAA rules. So let's turn to talking about breach notification on the federal and state side. What is a breach? It's a, HIPAA defines a breach as the acquisition, access, use, or disclosure of PHI in a way that is not permitted by the privacy rule and which compromises the security or privacy of the PHI. A breach only applies to unsecured PHI, which of course is PHI that has not been rendered unusable or undecipherable via an encryption process or destruction. If the information is encrypted or destroyed, then of course the unauthorized access is not a breach due to the fact that this circumstance of encryption or destruction presents little risk of harm to anybody whose information might have been obtained. Some examples of breach. A breach can come in many forms. We unfortunately see them all the time. There are some nuances to what is and is not a breach. A breach can exclude the unintentional access of PHI by someone, a workforce member or provider acting in good faith who doesn't further use or disclose the PHI, but actual snooping of medical records outside the normal course of treatment can be considered a breach. Breaches also include things like hacking incidents, misdirected information due to human error. a breach also can occur where a device that contains PHI, such as a laptop or a USB drive, is lost or misplaced, and the PHI on that device or drive is not encrypted. From a federal standpoint, breach notification requirements are resting with the HITECH Act, which was enacted in 2009. That's the Health Information Technology for Economic and Clinical Health Act. I don't know how long it took them to figure that acronym could be used as HITECH. Obviously, I think they named the act to make that so. But this HITECH legislation, of course, promotes and adopts the meaningful use of health information technology, but it also strengthened HIPAA to address the privacy impacts of expanded use of EMR and provided breach notification requirements. So the breach notification requirements, of course, have to be compared to your state law breach notifications, which we'll go over in a second. And if they don't conflict, both the federal and the state rules have to be followed. If they do conflict, you of course want to apply the stricter of the two. So in Louisiana, we have the Database Security Breach Notification Law of 2006. The notification obligations of this law that apply to all entities that own or possess data that includes Louisiana residents' personal information. In the event of a breach, this law requires notice to the affected individuals and the Louisiana Attorney General. The personal information that's covered under this law is defined more broadly than PHI under HIPAA, since it includes non-health identifiers such as financial information, for an example. The information accessed contains the resident's name and additional data, then it's considered to be a breach. The law that I referred to, the Database Security Breach Notification Law, does exclude the publicly available information, of course. And like HIPAA, it does not include information that's encrypted or redacted, or where there is no reasonable likelihood of harm to the affected individual. Here, under Louisiana law, it's important that entities that suffer a breach timely notify the Louisiana Attorney General's office, because a failure to make that notification could result in fines up to $5,000 per day. Also, unlike many other breach notification laws, I wanted you to be aware that Louisiana allows for a private right of action for persons that are harmed by violations of the law. This kind of situation could include direct harm suffered from the breach, such as identity theft, as well as the right to recover actual damages for failure to give a timely notice. So the protections of this law and the right of action only extend to those of you who are resident in Louisiana. So what are some of the consequences of a breach of unsecured PHI? In the event of an identified breach, the covered entity or the business associate has to make a number of notifications depending on the number of individuals that are affected by the breach. But in all cases, notifications have to be made within 60 days, and the covered entity or the BA has to notify each person whose unsecured PHI has been improperly accessed or acquired as a result of the breach. They have to notify the Secretary of HHS with the timing of that notification being dependent on the number of individuals that are affected. And if the breach affects more than 500 people, the BA or covered entity has to notify prominent media outlets that serve the area. As you see, that happen from time to time. So what if it's what is it that it may not be a breach? What may be exceptions to that? Not every impermissible use or disclosure of PHI rises to the level of being a breach. I've alluded to that a little bit before. Under certain circumstances, it can be determined that a breach did not in fact occur. So when you see something like an encryption or destruction, or like I mentioned before, permitted uses or exceptions where there's a low probability that exists that a privacy or security was compromised, that might not be a breach. Covered entities and BAs, need to, of course, investigate the specific facts and circumstances to determine if an incident did in fact occur, whether there is an exemption or exception that could apply. HITECH only contains 3 narrow exceptions to the breach rule. The first one is the unintentional acquisition, access, or use of PHI. So, for example, if a technician accidentally opens the wrong patient chart, or a healthcare provider opens the wrong chart while carrying out her authorized duties and responsibilities and does not further use it or disclose it, immediately finds that it is not the right chart and closes the access. Another is an inadvertent disclosure of PHI to an authorized person within the covered entity or business associate, such as maybe an example might be when a nurse emails the wrong lab results to a doctor and the email is deleted immediately and not further used or disclosed. The recipient would not be reasonably able to retain the PHI. That would be an exception to a breach that would need notification. Such as when a clinic mails an explanation of benefits to the wrong individual, and the post office returns the letters unopened. That would be an example of no breach. But if the EOBs were not returned by the post office as unopened, they would have to be treated as potential breaches. But if an exception applies, there's no notice to the individuals involved, to the government or media, even if the information was unsecured and disclosure not permitted under HIPAA. So if that occurs, if an exception applies, no notice of breach, it's not a breach. Wanted to talk a couple minutes about risk assessment. It's really important in the process of breach assessment and notification. There's a presumption of a breach where an impermissible access, use, or disclosure of PHI has occurred. The covered entity or the business associate has to conduct a risk assessment of the incident so that it can determine the extent of the breach and show that there is a low probability that the PHI has been compromised, if that's the case. The risk assessment has to be conducted in good faith, though, and the conclusions drawn from the risk assessment have to be reasonable. It has to connect. The dots have to connect when you're investigating these sorts of things. In any event, the covered entity and the business or the business associate can proceed with notification of the appropriate parties without having to conduct the risk assessment first. That emphasizes the speed of the notification over the risk assessment. So a risk assessment is supposed to be a thorough assessment, a thorough investigation that includes what would be a reasonable interpretation of at least these 4 factors. The first is the nature and extent of the PHI that was involved, including the types of identifiers and the likelihood of re-identification. Secondly, the unauthorized person who used the protected health information or to whom the disclosure was made. Third, whether the PHI was actually acquired or reviewed by someone else. And fourth, to the extent to which the risk to the PHI has been mitigated. At least those elements have to be included in the risk assessment. Risk assessments are also required in the event of a violation of the minimum necessary rule or the improper use or disclosure of PHI within the CE, the covered entity, or the business associate. Because a breach is presumed to have occurred in this situation, risk assessments are voluntary activity that should be pursued only if the covered entity or business associate reasonably believes an exception to the breach rule applies. Otherwise, you can proceed directly to notifying the appropriate parties. But if a risk assessment is conducted, covered entities and business associates have to be able to show their work, show their math. So that means, to carefully document how the conclusions were made in the assessment and how that was reached. In the event of a potential breach, we think it's the best practice that covered entities and business associates promptly take all corrective actions and document their response. Documentation is crucial in healthcare, is crucial in HIPAA. This is going to be very helpful down the line as HHS is going to be very much more unlikely to take a formal enforcement action against an entity if you can show that you took steps to fix the issue. So this was the next topic on compliance with limited resources, something that I wanted to be sure to include. Danae and I talked about it being important to your group, and recognition of the fact that some of your members are limited staff and have limited resources. So I picked some key strategies for compliance that might be helpful. And I will warn you in advance, for some reason, the program did not number these items consecutively, so I apologize. The numbering begins anew on each slide. But there obviously, compliance is essential. I mean, that's a given. But the challenges that are associated with having limited resources dedicated to funding personnel and dedicated resources to operate a compliance program, these challenges can be overcome by taking a number of steps to comply with HIPAA effectively. The initial points I wanted to make are seem rather obvious, but I think they merit discussion. First, educate staff. You have to ensure that all your staff members receive training on HIPAA. And this is really important. This will help them understand their roles and responsibilities in safeguarding PHI. There's free training available. When you get this presentation, I think there's a link to the Office for Civil Rights summary of the privacy rule and guidance materials. And I also provide training. My group provides training and materials, policies and procedures on education in relation to HIPAA. Second on this slide is conducting risk assessments. You don't want to do this all the time. It's too much trouble, and you don't want to conduct it too frequently. But the opportunity to conduct risk assessments a couple times during the year is important. This will give you an opportunity to gauge the severity of exposure and address opportunities for better compliance accordingly, even with limited resources. This really does help. I think if you are able to do this at least annually, but a couple of times a year is great. Third on this slide, develop policies and procedures. Obviously, I mean, we're into HIPAA quite some time. You should have comprehensive policies and procedures on how PHI is handled, stored, and transmitted securely in your organization, including access controls, things like data encryption, password policies, and proper disposal methods. Clear guidelines ensure consistency in protecting health information. As I mentioned, my group also has a set of policies and procedures that can also be accessed, and there are other resources available. On this slide, the next item is implementing physical safeguards. You want to implement safeguards that will secure areas where PHI is stored or accessed. You can include locked storage areas, restricted access, surveillance, proper disposals of physical documents, things like that. You do want to implement technical safeguards as well. Utilization of technical measures that, if you can, protect PHI in electronic form is very, very helpful. This includes basic things like secure networks, firewalls, encryption, strong authentication methods, and regular updates to software and systems that address vulnerabilities. Also, a third on this slide is limiting PHI access. Implementing appropriate access controls and user authentication mechanisms will ensure that only authorized individuals have access to PHI. Restrict access based on what we call the principle of least privilege, which allows only the minimum necessary information for staff members to perform their job responsibilities. Fourth on this slide, train employees on security. Do provide ongoing training to staff regarding best practices in security, such as how to avoid phishing emails, recognizing potential security threats, and reporting suspicious activity promptly. Awareness of staff, your awareness is a crucial thing in preventing data breaches. Our firm runs these tests rather frequently. And I've gotten caught clicking on a phishing expedition that our IT staff set up, and I undergo training when I make a mistake. It was a very believable email that I was sent, yet I got caught, but I can't tell you the value of this kind of training. Monitoring and auditing. You want to regularly monitor and audit your systems, your networks, access logs to see if you can detect any unauthorized use or access breaches promptly. This is going to help you identify and address security incidents that reduce the obvious impact on patient privacy. HIPAA doesn't really state a specific requirement about how often you should conduct internal audits, but as with the internal risk assessment that I referred to earlier, it's recommended to perform audits at least annually. And of course, we've talked about BAAs. You need to be sure that any external entities or vendors that you work with that may handle PHI on your behalf sign appropriate business associate agreements. I've talked about these agreements. No need to go into that any further. But I have template business associate agreements available. The U.S. Department of Health and Human Services has free template BAAs if needed. Third on this slide, document your policies and procedures. We want you to maintain detailed documentation of all your policies, your procedures, risk assessments, and training sessions. This documentation is going to demonstrate your continued compliance and commitment to compliance to serve as a reference for staff and auditors. Any third parties that are looking at your compliance program and wondering whether it's alive and well will benefit from maintaining and audit these records of audit and review. So it's important to remember that compliance with HIPAA is an ongoing process, and it requires continuous efforts to address all of the evolving security risks that are out there. So, even with limited resources, I think that you can prioritize things that have the most significant impact, such as the things that I've mentioned here, that will have the most impact on protecting patient information and will help you work toward improving your compliance posture over time. So I think that takes us to what I think is our last section on liability and enforcement. It looks like I have about 10 minutes for that. Let's look at this, lawsuits for HIPAA violations. There's no private right of action under HIPAA. There can be under Louisiana law, but there have been successful state law claims for negligence and invasion of privacy. Their class action suits for HIPAA violations are typically dismissed because it's really difficult to prove damages, but evidence of damages are getting to be more common, particularly in situations like identity theft. In a number of states, the Attorney General, including yours in Louisiana, can bring an action on behalf of patients for HIPAA violations and seek injunctive relief as well as damages. And of course, the covered entity can sue the business associate for a violation of the business associate agreement. So it's important to follow the BAA. Just a quick look here. The regulatory enforcement, some of my data is a little bit old, so forgive me for that. We couldn't find more recent data, but this process has not changed. The U.S. Department of Health and Human Services Office for Civil Rights is in charge of regulatory enforcement, as you probably know. Once a complaint is received by OCR, they review it and they determine if there's standing to go forward. For instance, if the entity is covered by HIPAA rules or if the incident occurred over 6 years ago. They'll take a look at threshold things like that. But if there is standing, OCR reviews whether a possible HIPAA rule violation occurred. And if that's the case, they'll proceed with conducting an investigation. The outcome can vary based on the number of circumstances, but OCR can certainly find no violation possibly. They can issue a formal finding of violation, and they can obtain voluntary compliance, corrective action, or other agreements with the violating entity. That's where I come in to negotiate a resolution. OCR also chooses to assist the entity in technical support so that they can ensure that whatever the issue is that is in front of OCR can be resolved. And here's the 2021 data. I couldn't find 2022 data. This shows that enforcement actions in 21, 78% of the complaints were resolved after they were reviewed and initially evaluated. Only a small percentage of complaints, I think it's 3% on this chart, actually resulted in an investigation and corrective action against the entity. An equal number of investigations result in a finding of no violation. At the end here, I just wanted to sort of go through some horror stories of situations in which regulatory enforcement actually occurred. Here, in these three cases, Banner Health, the Office for Civil Rights, obtained a settlement with an Arizona system following a hacking incident that disclosed PHI for almost 3 million customers. Banner Health got penalties due to a lack of a risk assessment, which is a common theme. insufficient monitoring and security compliance, as well as lack of encryption. The penalty included over $1.2 million fine and an imposition of a corrective action plan, which is a plan that's really cumbersome. It's like sort of a corporate integrity agreement situation where there are requirements that are imposed by the government to strictly adhere to in order to resolve the underlying issue that caused the breach in the first place and demonstrate continuous compliance with HIPAA. The Hope Labs case very quickly is a diagnostic laboratory failure to provide patient access to records in a timely manner. They received a $16,500 penalty and a corrective action plan requirement. New Vision was a settlement with a dental practice to solve an impermissible disclosure of PHI in response to online reviews of data. New Vision received a $23,000 penalty and a corrective action plan. Hospice of North Idaho, these guys received a settlement involving the theft of an unencrypted laptop that contained electronic health information of 441 persons, and it subjected the hospice organization to penalties due to, again, the lack of a risk assessment, the lack of a security rule compliance, and no encryption at all. They received a $50,000 penalty and the requirement for the corporate integrity agreement, or the corrective action plan. There were multiple settlements with 3 dental practices that were due to their failure to provide patient access to records. Those penalties ranged from $25,000 to $80,000, and each practice got involved with a corrective action plan. The Northeast Dermatology case is a settlement due to the disposal of empty specimen containers that were actually labeled with patient information, or that was found in an unsecured dumpster. They received over $300,000 penalty and, you guessed it, another corporate or integrity or a corrective action plan. I always default to corporate integrity agreements because they feel an act is the same in every instance. Now, at Oklahoma State, they experienced a breach and settled with OCR, with Oklahoma State Center for Health Sciences. They had a breach that affected almost 280,000 individuals after some malware was uploaded to a web server where staff had apparently improperly stored folders that contained PHI. OSU did not have an appropriate risk assessment and security rule compliance, and they failed to provide appropriate breach notification. In this case, Oklahoma State was subjected to an $875,000 penalty and another corrective action plan. Now, this is the biggest I'm saving for the last, and here we are almost at the hour. Premera Blue Cross. OCR reached a settlement with Premera Blue Cross, who reported a phishing attack that got them, and it disclosed the electronic health information of almost 10.5 million people. Premera did not do an appropriate risk assessment. They did not implement an appropriate security measure and to contain this, and they were subsequently hit with a $6,850,000 penalty and a corrective action plan. So you can see the common themes on these regulatory enforcement examples. There's one, for every single individual situation, and they're not all the same. We don't have enough time obviously in this presentation, because I'm right at the hour, to go into things like to go into things like malware and ransomware, things of that nature. That's a whole nother discussion that we can have at a later time. We can also do risk assessments, sort of a tabletop exercise to go through how you would perform in a risk situation to do the compliance that we've been talking about here. If you have any questions, I apologize, this took the whole hour, but I hope you can see my address, name, email address, and I would love to hear from you if you have any questions. And again, Danae, I apologize. I was afraid this was going to take to the bitter end, and it did.
No problem, no problem. We are right at the hour. We do have several questions in the Q&A box. So what I'm going to do is I'm going to download those and I will email those to you, Bob, and you can answer those in writing, and we'll send those out to everyone who registered. So you'll have those answers in writing. Thanks again for joining us. Bob, thank you for your presentation. Thanks everyone for joining. When you exit the session, as a reminder, you'll get automatically in your internet browser, you should get a post survey. If you have any comments, please put them in there. Any of the additional things that Bob mentioned at the end, tabletops, things like that, if you're interested in those, put those in as additional topic ideas in that survey. There is a space for that. So go ahead and put anything in there that you are interested in seeing in the future, and we'll try to facilitate that. Again, a recording of the webinar along with the slides will be on our website within the next couple of days or so. And as always, if we can be of any assistance, please feel free to reach out to us. And unless there's any final comments from Bob, we can wrap up for the day. Thanks everyone so much and have a wonderful afternoon.
Just thank you for everyone, and look forward to hearing from you.
Thank you so much.
Bye-bye.